let's get going.
So, my guess is we may have a few more people appearing. So, if those close to the door are those who have spaces, Jeff, I'm really going to be here. If you could just make sure that no seats, I can see a seat there, I can see one there. We may even have to take out the discussion seats. But this, I can see some, do come in. Thank you. My name is Professor Liz Fisher. I'm Professor of Environmental Law here at the faculty, and my job this evening is to introduce the second of this Clarendon Law Series. This year, the Clarendon Law Series turns 30. The first in this series was in October 1995, and it's a series of lectures from Richard Posner, and I actually was there. Now, I asked, because I thought I should get sort of modern, I asked AI, what does it mean to turn 30? And it told me a lot of kind of vague stuff, although it did say hangovers might last longer and metabolism can slow down. But among the vague statements, what it said was, well, when you turn 30, you figure out what is important. And I think the lecture last night highlighted what is important about the Clarendon Law Series. First, these lectures are a big intellectual task. Phil Cornish, in his Clarendon lectures, said, it is the task of saying something coherent in the relatively small compass allowed by the lectures. And that task is important. Law is complex. Trying to get a coherent picture of that landscape is really difficult. And that coherence we experienced last night. No one could come away with that lecture without having a useful map of the executive and as an institution and its complex and active and reflexive role in constitutional practice. And it was that coherence which not only illuminates that role, but helps us as scholars begin to navigate it. The second important thing about these lectures is they represent an opportunity to have different types of scholarly conversations. So John Baker and Nicky Lacey used their lectures to bring different things into conversation with each other. For Lacey, that was law's doctrinal and conceptual being with its institutional and practical reality. For Justice Bill Gummo, riffing off Sir Jack Beatson, it was bringing statute and common law, oil and water together. And what we saw last night was the bringing together of a diverse array of scholarly literature with constitutional practice. And that shows that the map that we were given last night does not get its coherence from limiting one's material or simply staying within the body of a certain type of construct. Third, the Clarendon Law Lectures have been an opportunity for what Jane Stapleton described in her Clarendon lecture as creative, interactive conversation between scholars and judges. Lord Sale's lectures joins those of other judges, Judge Posner, Justice Breyer, Justice Gummo, and Lord Collins. For scholars, the importance of this conversation between judges and scholars is that we as scholars need to make sure that the models that we use reflect the reality of legal worlds. ChatGPT's response to what does it mean to turn 30 ended with a question to me, how are you feeling about turning 30? A reminder that assumptions can be incorrect in many different ways. More seriously, the task of scholars is particularly challenging when, as Judge Posner noted in his lectures, life has the disconcerting habit of not standing still for scholarly reflection. What was striking last night in the lecture is Lord Sale's map was a map of things in action. It was dynamic. It was getting us to take those dynamics seriously and the constitutional actors and materials seriously. Gunter Treitel, in his Clarendon lectures, said that his main debt as a scholar was to the subtlety, inventiveness and ingenuity of the English bench and bar. A reminder that as scholars, we need to develop an ongoing an empathetic relationship with the material and the people who study. In that regard, Jules Coleman, noted in his Clarendon Lectures, you can probably figure out what I read preparing this, said that the life of the scholar is an extended educational experience. That is what is wonderful about being a scholar. It is what is wonderful about the Clarendon Law Lecture series. And it was what was wonderful about the lecture last night. With that, I invite Lord Sales to take to the stage, and I invite you to enjoy. Thank you.
Good evening, everyone. Thank you again for coming to listen to this lecture. The title for this evening is Parliament as Constitutional Agents, having dealt with the executive yesterday. Parliament has a long history as the body which represents the nation and has full lawmaking power in respect of it. The doctrine of the sovereignty of Parliament also has a deep history in the UK's constitutional law. The idea of the sovereignty of Parliament is a claim for full agency for Parliament in terms of making laws. That is not the same as full constitutional agency, because Parliament does not govern. It acts to make laws in response to proposals put before it by members, typically those who form the government. The executive has wider constitutional agency in the sense of the power to act and get things done. As explained in my last lecture, the executive government, through its control of parliamentary procedure based upon its command of a majority of MPs, has prior agency in terms of securing legislation. It has the power of initiative in presenting legislative proposals to Parliament to activate Parliament's lawmaking power. The difficulty of Parliament exercising constitutional agency in this wider sense was demonstrated by the problems encountered during the Brexit period in 2019. So great was the controversy within Parliament and within the ruling Conservative Party regarding the form of the Brexit arrangements with the European Union, that for a comparatively brief time, the government of the day lost control of the parliamentary process, and groups of MPs tried to come together to legislate for a different policy. The groups lacked internal coherence and failed in that endeavour. This was an object lesson in how constitutional agency and legislative initiative is generally dependent on the prior activity of political parties in producing coherent policy proposals, and then of the executive in carrying them through Parliament. Nonetheless, the executive government does not have the power to produce primary legislation. It has to seek to persuade Parliament to do that. Parliament is a representative institution, which is the embodiment of the democratic principle in the Constitution. Democratic deliberation implies the possibility of choice and change. Lord Lefort writes, "The important point is that democracy is instituted and sustained by the dissolution of the markers of certainty. It inaugurates a history in which people experience a fundamental indeterminacy as to the basis of power, law, and knowledge, and as to the basis of relations between self and other at every level of social life. A process of questioning is implicit in social practice, that no one has the answer to the questions that arise, and the work of ideology, which is always dedicated to the task of restoring certainty, cannot put an end to this practice." Hans Kelsen, in his work of 1929, The Essence and Value of Democracy, similarly defended democratic parliamentary rule on the grounds of a principle of freedom. The principle of freedom is also the basis of the demand for political equality, which is central to democracy. If I am free, what gives someone the right to rule over me? All must have an equal share in the exercise of ultimate political power through the ballot box. Freedom to choose is important because there is no objective standard of political truth available on which all agree. So the idea of democracy presupposes relativism as its worldview and a pluralistic perspective regarding values. On Kelsen's account, in societies which are pluralistic with no consensus belief in absolute truth and absolute values, only relative truths and values are available to human cognition. As he puts it, the metaphysical absolutistic worldview is linked to an autocratic and the critical relativistic to a democratic disposition. Everyone's political will is valued equally. There is equal regard for political opinions, and the right to govern depends on competition for public support. But Kelsen also noted that democratic self-government is only possible within the framework of a constitutional order. The people does not exist as a rarefied sociological entity. It requires a set of legal procedures to determine how it can express itself and therefore govern. Tellson's point is that democratic self-government is possible only within the framework of a constitutional order, because this is what defines the procedures that enable the people to govern themselves in the first place. The democratic process is a form of constitutionalized politics, inasmuch as rules and procedures are essential for making it work. The same procedures that make the expression of the popular will possible in the first place also function as limits on what it can legitimately be taken to be. So popular sovereignty is limited by the logic of its own exercise. I put it this way: the constitutional rules are the grammar of the system, which enable a coherent and legitimate form of collective will to come into being. We have arrived at these views about the importance of democracy after a long process of the development of ideas. Democracy was a derogatory term at the end of the 18th century. It came to be the dominant paradigm of government only towards the end of the 19th century and into the 20th. In the UK, this ideological process was linked with the expansion of the franchise. But the history of Parliament's constitutional agency as the dominant lawmaking body is much longer than this. I would highlight 5 stages. First, in medieval times, statutes were treated as being, in effect, part of the common law. They were like judgments of a high court, to be woven into the fabric of the common law as a whole. They could be used, like case law, as a foundation for analogical reasoning. Second, a decisive change occurred in Tudor times. Henry VIII and Thomas Cromwell used Parliament and legislation to give legitimacy to the Henrician break from Rome. As Chris Thornhill writes, during the English Reformation, the principles of rule by the King in Parliament became a key legitimating device of royal government. This meant that Parliament's own authority was enhanced, with the consequence that the courts began to treat the will of Parliament, as expressed in the words it used in statutes, as having special force. As Alan Cromitty explains, one sign that people were impressed by parliamentary power was that they placed increasing stress on Parliament's historical intentions. Third, the Glorious Revolution of 1688 affirmed the dominance of Parliament over the Crown. The absolutist form of monarchy, which was becoming more prevalent on the continent, which Charles II and James II were seeking to copy, was decisively curbed. The Bill of Rights of 1689 removed any suggestion that the monarch had a power of dispensation from statutory law. The settlement of 1688-89 affirmed that Parliament alone had the power to impose taxes and to vote money supply from the consolidated fund. This control of tax and spending provides the material foundation for the doctrine of parliamentary sovereignty, which reached its fully developed form in the canonical statement by Dicey in the late 19th century. Article 9 of the Bill of Rights protected parliamentary processes from challenge in the courts. The Act of Settlement of 1701 represented the use of Parliament's authority to modify the line of succession to the throne. Four, the positivistic approach to statutory interpretation was powerfully reinforced in the course of the 19th century. 3 factors were particularly significant here. First, growing adherence to a concept of parliamentary sovereignty and supremacy, culminating in Dicey's exposition. Secondly, the growing force of democratic ideology linked to the expansion of the franchise. Thirdly, as Neil Duxbury explains in his Elements of Legislation, a loss of confidence on the part of the judiciary in the face of greater parliamentary expertise and access to sources of information regarding social problems. Duxbury dates this to the early part of the 19th century. The judges felt less well informed and so were reluctant to develop the law by reference to policy, so that the common law was seen as subordinate to statute. Fifth, the growth in the welfare state and the financial commitments of the state in the 20th and 21st centuries mean that parliamentary control of tax and spend has increased the practical power and authority of Parliament. Combined with the fact that the judges are not constitutionally in a position to second-guess the choices made by Parliament, the loss of confidence referred to by Duxbury, and the Kelsenian sense that in a world of pluralistic values and relativism, what matters is authoritative democratic choice to prioritize certain values over others. This has tended to reinforce acceptance of the sovereignty of Parliament. The sovereignty of Parliament is the subject of Part 1 of Dicey's Law of the Constitution. It means that Parliament has the right to make or unmake any law whatever, and further, that no personal body is recognised by the law of England as having a right to override or set aside the legislation of Parliament. Strictly speaking, Parliament is the King, the House of Lords, and the House of Commons acting together. However, under modern practice, the King is a mere cipher and figurehead, and the elected House of Commons is the dominant element, which is capable of enforcing its will on matters of policy and legislation. Prior to Brexit, the European Communities Act 1972, which gave domestic legal effect to the UK's membership of the European Union, made a major inroad on the principle of parliamentary sovereignty. It gave the courts authority to disregard UK legislation, which was incompatible with EU law. However, even then, parliamentary sovereignty as such continued, in that this effect was the product of the interpretation of the 1972 Act, and it was at all times possible for that Act to be amended or repealed. The principle of parliamentary sovereignty means that the distinction between constituent power and constituted power, so important on the continent, is collapsed in the UK. The prominence of the conventional or customary aspect of the UK's constitution arises from this fact. As Neville Johnson writes, I'm citing him quite a lot this evening, it has been difficult and perhaps logically impossible to sustain a formal constitution in Britain, since in that case the terms of the constitution would have to take precedence over the claims of Parliament. The implication of this is that to a large degree constitutional law has to be approached in the guise of statutory interpretation. Constitutional norms, including those found to be implicit in legislation, can always, in theory, be overridden by ordinary legislation expressed in sufficiently clear terms. The effect is that the Constitution is flexible and can readily adjust in the light of changing political forces and circumstances. This makes it resilient. But it also means that it is more vulnerable to change and manipulation on the initiative of the executive through its control over the legislative process. Johnson observes that the conventional aspect of the Constitution has implications for the style of constitutionalism and constitutional law in the UK. Quote, the language of constitutionalism is something like a conversation within a tradition of argument about how society should be governed, whilst the language of constitutional law tends to be in terms of underlying principles as stated in the Constitution and such deductions from them as specialists in constitutional law might make. Quote, at the political level, much of this conversation takes place within and between political parties. Towson emphasised the importance of political parties as central to modern forms of democracy. They bring people together to decide on coherent proposals for government in order to secure actual influence in shaping public affairs. In the UK in particular, the sense that national identity is expressed through Parliament is bound up with the role that political parties play in the political system. Erskine May argued that contestation through the party system underpinned the freedoms of the polity. As Crowcroft explains, quote, deep antagonisms could be fought to a legitimate resolution. Political parties carve out and safeguard a vital space for practical pluralism and a multiplicity of views, offering clear choices to the electorate and giving cohesion to the executive. Where governments had the numbers in the House of Commons, they could act with vigour, which incentivised ambitious politicians to appeal to a large section of the electorate, and party platforms offered an instrument through which voters might judge success and failure. Moreover, since leaders were vulnerable to pressures from followers and their position was dependent on merit, parties acted as a crucial check on the executive, and the presence of an opposition meant there was a credible alternative government which could quickly replace a government which was voted out of office. Party competition, therefore, strengthens Parliament as a national representative institution, since its responsiveness to public problems serves to reaffirm its authority and legitimacy. And since parties competed to control this institution rather than reform it, this contributed to stability and the possibility of peaceful political change. But the Brexit debate cut across party lines. That is one reason why it proved to be somewhat indigestible in constitutional terms. Another is that parliamentary democracy is representative democracy, whereas the politics of Brexit involved an appeal to direct democracy in the form of a referendum. This imposed a significant political constraint on the agency of Parliament itself. The fact that the UK is a parliamentary democracy rather than a plebiscitary democracy defines the relationship between MPs and their constituents. MPs are not delegates mandated by their constituents to vote in a particular way. They are representatives who vote on behalf of their constituents, but exercising their own judgment regarding the common good, even if that diverges from the views of their constituents. This was explained most famously by Edmund Burke in his address to the electors of Bristol. The constitutional form of democracy in the UK is therefore representative rather than direct. The touchstone for selection of the Prime Minister and the executive government is whether they can command a majority in Parliament on key issues of policy. And in normal times, Parliament is typically a vehicle for government by the executive. In that way, executive and democratic power is usually aligned. But through the breakdown of party discipline under the pressure of Brexit, that alignment fell apart. It's possible to offer an analysis of the Brexit target in democratic and constitutional terms. By choosing to put the Brexit question to a national referendum, David Cameron's government created a tension between the principle of representative democracy, by which the UK is governed, and the principle of direct or plebiscitary democracy. Referendums are not without precedent in the UK, but British constitutional law does not give them a substantive role. There is a clear mismatch between their formal legal status and their practical political effect. The formal legal status of the 2016 referendum was that it was advisory only. The government and MPs could choose to ignore it, but its practical political status was essentially as a trump card. The government made promises that it would abide by the result. MPs recognised that whatever they might think about the merits of Brexit, contrary to Edmund Burke's account, their hands were tied in terms of endorsing something that could be called Brexit, and they were very vulnerable to political narratives designed to treat anything less than a hard form of Brexit as not Brexit at all. The political slogan, Brexit means Brexit, was not enlightening. However, it did have undeniable political power. For MPs to apply their own judgment against this would risk discrediting democracy as a principle. The general public had been invited to vote on the question and could not be expected to make nice distinctions regarding the precise constitutional status of what they had done. MPs therefore had to struggle to try to reconcile the constitutional principle of representative democracy with the alien principle of direct democracy. The principle of the sovereignty of Parliament came under pressure as the government then sought to give effect to the Brexit vote in a way which would command acceptance with the public, first and foremost, but also with a majority of MPs. There was an important complicating factor. As part of a deal for coalition government in 2010, the Conservatives under David Cameron had agreed to legislation which set a fixed 5-year term for an elected Parliament, subject only to a vote of MPs before then to call for a general election or to register no confidence in the government. Under the old rules, if a government could not get a major policy to Parliament, the Prime Minister was entitled to call an election to put the issue to the test in a general election, seeking to get sufficient backing in the country to get a majority of MPs to support the policy through Parliament. Theresa May, who succeeded Mr Cameron as Prime Minister, secured a modification of the new law in order to hold a general election in 2017, in which she hoped to secure a commanding majority for her particular proposed version of Brexit. But her gamble misfired, and the Parliament which was returned was one in which there was no clear majority for any version of Brexit, but also one in which MPs felt that, unusually, they rather than the government were in the driving seat, so far as making policy on this issue is concerned. Boris Johnson, the Prime Minister who succeeded Mrs May, was a proponent of a hard form of Brexit, to which a majority of MPs were opposed. By this stage, negotiations with the EU were at a critical juncture, and MPs did not wish to relinquish their unusual power over the making of policy, so they would not vote for a new general election. Therefore, until a deal was done with the opposition parties to allow a new general election in December 2019, Mr Johnson was forced to live with the recalcitrant Parliament he had inherited. This unfolding political picture provides the background for the two Miller cases in the Supreme Court, and I'll discuss them in my final lecture. In the first Miller case, the Supreme Court held that legislative approval from Parliament was required before the Article 50 notice to withdraw from the EU was given. In the event, there proved to be little difficulty getting the relevant legislation through Parliament. The second Miller case took place when Boris Johnson was in a certain sense a prisoner of Parliament because because of the fixed term legislation, at a critical point in the government's negotiations with the EU on the terms of Brexit, he wished to be free of the risk that a majority of MPs might take action to limit his freedom of manoeuvre in those negotiations. Johnson asked the Queen to prorogue Parliament for a period of 6 weeks at this critical juncture. In the Miller 2 judgment, the Supreme Court held that the prorogation was unlawful. This judgment, like that of Miller 1, sought to uphold the authority of Parliament against the claims of the executive to be able to rule without reference to it. However, again, this had little political impact. The reasons for this lie in the way in which the British Constitution is fashioned, around the executive as the active ingredient. It is the executive, through its party organisation and control of business in Parliament, which proposes policy programmes and initiates legislation to implement them. Outside those structures, MPs are not well positioned to assume the initiative themselves. They prove to be incapable of forming a cross-party alliance to stop the government's negotiation position being carried through. The final denouement was the December 2019 general election. In a political miscalculation, the opposition parties agreed to vote for this election ahead of time. The Conservatives under Boris Johnson won a decisive 80-seat majority on its programme to get Brexit done. In political terms, this election restored the functioning of the Constitution around its traditional fundamental principles. The Brexit outcome from the application of the alien principle of direct democracy has been brought back into alignment with a Brexit outcome secured in conventional means in the general election, pursuant to the traditional principle of representative democracy. The Act fixing a set term for Parliament was repealed. Now, there are further political constraints on the agency of Parliament, and there are also legal constraints on it. To take the political constraints first, I would highlight 4. First, as I mentioned yesterday, there is a mismatch between the increased need for positive law in modern society and the essentially fixed size of the House of Commons. That has not grown since the 19th century. As the demands on Parliament have grown, its relative capacity to exercise its own agency in dealing with them has been eroded. The practical effects of this have been to place a high premium on parliamentary time as a scarce resource, and to foster the growth in the use of subordinate legislation by ministers with minimal scrutiny in Parliament. This means that a great deal of legislation is being created without substantive exercise of judgment by Parliament itself. Second, the Burkean model of deliberative democracy has come under enormous strain. This was a model for the exercise of considered judgment by Parliament itself as a collectivity. It is this model at the heart of Jeremy Waldron's argument for upholding the dignity of legislation based on a rather idealised deliberative democracy in Parliament. Now, MPs rarely engage in substantive deliberation with each other in holding the government to account or before legislating. An aggregative model of democracy has become predominant based on party loyalty. Neville Johnson writes that the rise of disciplined political parties, often claiming a mandate to act by virtue of an electoral majority, has introduced a profound ambiguity into the relationship between Parliament and the government. Is the House of Commons there to confer authority on the executive and to exercise a critical and controlling function in relation to its members? Or is its main function now to facilitate majority rule and the fulfilment of promises made by parties in an election? According to Johnson, Burke's theory of representative democracy, with loose political parties and an emphasis on policy formed through debate, is all but dead. There has been a shift away from the idea of representation emphasizing the independence of judgment expected of the representative, and towards acceptance of the primacy of party ties in the competition for electoral support. Political parties offer programs for the electorate reduced to simple promises and careers to their candidates. It is on this essentially populist foundation that parliamentary government in Britain has assumed the character of mandated majoritarian government or majoritarian democracy. Further, such has been the expansion of the governance function that Parliament no longer has the capacity for continuous supervision of the executive. These changes are associated with profound underlying changes in the nature of the state. Johnson points to a big shift in expectations as to the role of the state since Dyce's time, which has put pressure on the workings of the Constitution. He characterizes this in terms of the rise and fall of negative liberty, by which he means hostility to extensive public powers, so that as far as possible, people should be free to do what they like, which ran into difficulties in the transition from a negative laissez-faire state to one committed to the promotion of economic and social welfare. This has been associated with a change in the role of central government and the terms of party competition. Traditions of institutional pluralism and powers diffused to local self-governing councils have been eroded as parties compete on national platforms to acquire and then use centralized state power. There has been increased emphasis on implementation of uniform nationwide standards of service provision. The driving force in a shift away from 19th century traditions of pluralism and subsidiarity has been the urge of national party leaderships to extend their capacity to meet the expectations of the electorate with a corresponding weakening of political leverage available to groups at local levels. The power of the executive operating within Parliament and making use of the supremacy of Parliament is largely free from the checks and balances imposed by the need to accommodate the constitutionally recognised rights of competing institutions within the political system. Johnson's diagnosis may be overly pessimistic in that there does remain scope for deliberation in Parliament, at least sometimes. The current debate about the law on assisted dying is an example, albeit it is not typical. The Waldron vision of the dignity of legislation is under pressure, but it is not entirely defunct. However, Johnson's diagnosis sets the scene for challenges which any constitution of a modern state has to face. The integration of popular will with respect to individual rights, effective appropriate control of the exercise of executive discretion in the delivery of services, and the maintenance of appropriate levels of subsidiarity for popular decision-making. The problems may be particularly acute for the UK constitution, since, according to Johnson, party interest in the acquisition and retention of power has steadily eroded norms of self-restraint by office holders and a sense of limits of powers, which is integral to liberal constitutional ideology. The interests of parties are given priority over the public interest, so institutional practices of restraint are in a state of decay. Already in the 1920s, Carl Schmitt called attention to the erosion of parliamentary deliberative democracy under the impact of mass party politics in his book, The Crisis of Parliamentary Democracy. The erosion of customary political norms of self-restraint means that there is pressure for law to take the strain and fill in gaps where the 19th century forms of government do not meet current needs. And I'll come back to that topic in my final lecture. Yet Johnson points out that the ideal of parliamentary government, combined with the first past the post electoral system, is still to connect voters to rulers through the key ability of the electorate to get rid of a government in an election. This remains the basis for popular acceptance of the regime. As he says, in the British constitutional tradition, the principle of parliamentary sovereignty really became another way of talking about the sovereignty of the people, democracy, and self-government. That is why the idea of Parliament and its unlimited authority has been so powerful in the popular imagination. It has stood for democratic self-government and for the affirmation that all executive authority is held in trust and that those exercising it must be publicly accountable to representatives of the people in a form of fusion of parliamentary and popular sovereignty. This aspect of the UK Constitution is fundamental to the respect for parliamentary sovereignty, which is the basis for the agency which Parliament continues to have. Moreover, public respect for Parliament means that it exercises agency through being the site for authoritative resolution of conflicts of interest and conflicts of view. Political conflict is such that aggregative democracy is ultimately necessary to provide binding decisions as the channel for social forces to be recognised and accommodated peacefully under generally accepted conditions. Indeed, recognition that one side has been defeated in a vote on an issue may be the best way of demonstrating respect for them in the political process, rather than in a pretense of a false deliberative unanimity. To be viable as a legitimate mode of governance, however, aggregative democracy requires a basic level of loyalty from the losers on a particular issue or in a particular election, that they will keep playing the game and accept its outcomes rather than overturn the board. Both the deliberative and the aggregative conceptions of democracy highlight an important feature of the political realm, which the legal realm cannot replicate. That is the scope it provides for compromise and negotiation in relation to competing interests. Outcomes arrived at through political compromise can accommodate many competing points of view. The court should be prepared to give effect to the legislative product of such compromises, recognizing that it may not reflect any single articulated principle, and without seeking to impose their own inconsistent solutions through interpretation. The doctrine of parliamentary sovereignty ensures that this is done. The third political constraint on the agency of Parliament is the rise of populist modes of politics. Brexit is a case in point. In one sense, populism is the essence of democracy, since democracy is governed according to the popular will. But as Kelson pointed out, questions arise how the popular will is to be identified and constituted. As Jan Miller pithily observes, the essence of democracy is that the majority have their way after the minority have their say. That is, majority rule is valid, but there should be respect for and a hearing of minority opinions. In a remark aimed at Rousseau and his conception of the general will, Hannah Arendt said that the political world is framed by and created for men, and of course women, not man with a capital M. Her point was that politics has to accommodate a plurality of views and values. It is dangerous to suppress this perspective by compressing humans with all their individuality into one theoretical, homogenized whole. For modern democratic politics, the fundamental political theory of sovereignty is that it is the people who are sovereign. In our system, as Dicey observed, this theory applies, but alongside it sits the legal principle of the sovereignty of Parliament. We have a representative parliamentary democracy. This juxtaposition of a political theory of popular sovereignty and a legal theory of parliamentary sovereignty is capable of giving rise to tensions. The idea that the people are sovereign opens up powerful rhetorical possibilities for political debate with a view to assembling political forces outside and within Parliament. If opponents can be portrayed as defying the will of the people, that is not a good look in democracy. Experimentation with direct democracy in the form of referendums, involving a direct appeal to the people to state their will by voting on some proposal, reinforces this possibility. The mantra of Get Brexit Done illustrated this. Some politicians were able to leverage the Brexit referendum result to promote outcomes they desired, and others found it difficult to resist that rhetorical appeal. Another set of tensions is created by the second pillar of the Constitution identified by Dicey, the rule of law. This is a rather ambiguous idea. It can be read as a relatively thin conception in the sense that law, however it is properly to be identified, has to be obeyed, including by the government. But it can also be read more extensively in giving greater substantive meaning. The more that happens, the more the meaning and effect of this principle is contested, the more substantive content is given to the principle of the law, the more attention appears to arise from the popular will as expressed by Parliament through the medium of legislation. Again, I'll return to this topic in my third lecture. In thinking about the scope of populism in our legal system, both these boundaries are significant. First, the boundary between representative democracy in Parliament and the notion of the will of the people as direct democracy, linking the people with political outcomes. And second, the boundary between the popular will expressed through Parliament and the rule of law. To complete the picture, one also has to understand the power of the executive in the political system, which I emphasised in my first lecture. Usually, the executive with a majority is able to work through Parliament and not in opposition to it. It uses Parliament as an instrument of rule. In an important sense, therefore, Lord Hailsham's description of our political system as an elective dictatorship carries force. Despite the pejorative language, that is not necessarily bad. Democracy would be discredited if elected politicians could not do effectively what they have promised the electorate they will do. But where should the limits lie? Jan Miller explains, quotes, populism arises with the introduction of representative democracy. It is its shadow. Populists hanker after holism, the notion that the polity should no longer be split, and the idea that it's possible for the people to be one and, all of them, to have one true representative. The core claim of populism is thus a moralized form of anti-pluralism. Populism requires a pars pro toto argument and a claim to exclusive representation, with both understood in a moral as opposed to empirical sense. There can be no populism, in other words, without someone speaking in the name of the people as a whole. End quote. To make such a claim is a rhetorical move in the political realm to silence debate, with the aim of generating political power and consequent on that, legal authority. It can be a move designed to suppress the agency of Parliament by eliminating the scope for genuine consideration and creating a fear of an electorate in which the possibilities for open debate appear to be much reduced. Around the world, populism is typically framed as anti-elite and expresses impatience with institutional constraints. It maximizes political claims and is dismissive of impediments to their realization. Populist politicians promise instant radical change. Then when it proves difficult to realize those aims in power, they need to be able to butt up against opponents whom they can blame for betraying the will of the people. Populism promotes popular as opposed to parliamentary sovereignty, and it is antagonistic. Since the 19th century, there's been a decline in the institutional constraints posed by Parliament. Under the pressure of mass democracy and the recruitment of political support for national party programs, there has also been an erosion of norms of political morality, which Dicey identified as a third pillar of the Constitution. These developments mean that the courts are left more exposed as defenders of the constitutional order. The prorogation case could be seen as a symptom of this. So each pillar of Dicey's account of the Constitution, sovereignty of Parliament, rule of law, and the rule of conventions, comes under pressure from populism. There is considerable scope for populist rhetoric in the UK's political system. Perhaps the greatest risk is in relation to claims by the executive to be speaking for the people, when using their considerable power within Parliament and their considerable legal powers outside Parliament. When the executive frames itself as the representative of the people, in opposition to Parliament and other institutions such as the courts, it risks the devalorization of institutions intended to secure the representation of all. The fourth constraint on Parliament's constitutional agency is the devolution of important aspects of government to the constituent parts of the UK, the Scottish Parliament, the Northern Ireland Assembly, and the Welsh Senate. This is not a fully federal system, as there is no assembly for England. The UK Parliament governs for England and has reserved powers in relation to the other nations, even where matters are not reserved to the UK Parliament under the relevant devolution legislation. The UK Parliament retains the power to legislate in the area of devolved matters as a function of the principle of parliamentary sovereignty. However, the devolved executives and the devolved assemblies have claims to democratic legitimacy for their nations, both as against the UK Parliament and as against the UK executive, which is elected predominantly on English votes and has a particular focus on England. Brexit has put pressure on the devolution settlement. So, for example, a majority in Scotland voted to remain, and the Scottish Government, Scottish Parliament, and Scottish MPs have pressed for a softer form of Brexit. In the first Miller case, the Scottish Government asked the Supreme Court to give legal effect to a constitutional convention known as the Sewell Convention, that the UK Government would not legislate on the matter affecting Scotland without first seeking to secure the agreement of the Scottish Government. The court rejected this argument. It again drew on established constitutional traditions derived from Dicey's schema to hold that the convention was just a matter of custom and practice, which did not have legal force. In a later case, the Scottish Government tested the limits of the powers of the Scottish Parliament under the Scotland Act 1998 to influence or veto the legal rules to be put in place by the UK Parliament to give effect to the Brexit deal between the UK and the EU in the continuity case. The Scotland Act preserved the principle of the sovereignty of the UK Parliament, so the Supreme Court found that the Scottish Parliament lacked the power to affect the legislation of the UK Parliament on this issue. And in the Indy Rev 2 decision, the Supreme Court held that it was not within competence for the Scottish Parliament to legislate for an advisory second referendum on Scottish independence, since this was designed to put political pressure on the UK Parliament and would undermine the agency of that Parliament in relation to deciding whether to take any action on this topic. So Brexit has placed the constitution of the UK under pressure on various fronts. But it has been found possible, ultimately, to secure the basic constitutional principles of representative democracy and the sovereignty of Parliament. Finally, I turn to consider the legal constraints on the agency of Parliament. And I will discuss these again in greater detail in my final lecture. The courts and Parliament have both moved to articulate or introduce significant constraints in relation to the exercise of agency by Parliament, principally in relation to individual rights. The flagship legislation here is the Human Rights Act. Section 3 enacts a strong interpretive obligation that legislation should be construed where possible, so as to be compatible with convention rights set out in the European Convention. This means that if Parliament wishes to legislate in a manner which is inconsistent with those rights, it has to do so in very clear terms, so that it is not possible to read the legislation in a compatible way. There is much litigation around this boundary. The practical implication in terms of parliamentary agency is that it imposes a sort of manner and form constraint on what Parliament can do. Parliament can override convention rights, but it is obliged to do so by proceeding in the right way. Where it is not possible to give legislation in an interpretation under Section 3, which is compatible with convention rights, a court can issue a declaration of incompatibility under Section 4. Formally, in domestic terms, this only triggers a ministerial power without obligation to promulgate subordinate legislation to effect a conforming amendment of the primary legislation. The declaration does not affect the enforceability of the legislation in question, according to its non-compatible meaning. However, where a declaration of incompatibility is issued, if the administrator does not make an amendment order, the individual affected by can make an application to the European Court of Human Rights, and it is likely that they will succeed in obtaining a judgment against the government. The declaration of incompatibility therefore has a practical effect which is far greater than the formal effect it has under Section 4. As Aileen Kavanagh points out in her recent book, The Collaborative Constitution, the government has always reacted to a declaration of incompatibility by changing the law to put it into a compatible form. Therefore, there is no formal power of strong form judicial review in the UK to strike down primary legislation. A declaration of incompatibility comes close to having that effect in practical terms. Although it appears to be something of a paper tiger on the face of it, it is in reality a very powerful remedy. It is a form of ex post facto constraint on the agency of Parliament, since it removes practical decision-making from Parliament to the courts and the executive government. For the executive government, this is one feature of its role in managing the interface between domestic law and international law. It is also a form of advanced constraint on Parliament, since if it wishes to pass legislation which will stand and be effective, it has to try to avoid producing something which is not compatible with convention rights. As I will discuss in my final lecture, the question of compatibility of legislation with convention rights often turns on the ambit of the margin of appreciation. One aspect of the doctrine of the margin of appreciation is that the greater and more careful the preparation of reports for and debate in Parliament, the wider the margin tends to be, and therefore the more likely it is that legislation will be found to be compatible. So Parliament has the ability under this doctrine to buy a wider margin of appreciation for itself by proceeding in a way which demonstrates that it has paid attention to the impacts on individual rights. This is a doctrine which tends to enhance the quality of deliberation in Parliament with a view to reconciling the collective and individual interests in an acceptable way. Finally, the courts have developed domestic legal doctrine in ways that both recognise and give effect to Parliament's agency, but also constrain it. The courts give effect to Parliament's agency by seeking to identify fairly and objectively Parliament's intention as expressed in the legislation it passes. As I mentioned at the outset, there is a very long history to this. Statutory interpretation is itself a form of constitutional law. The focus on identifying Parliament's intended meaning is a focus on recognising and respecting its agency in the Constitution. By the use of recognised canons of interpretation, the courts also constrain Parliament to some degree in the exercise of its agency. They do this through applying the principle of legality as a presumption of interpretation of legislation. The principle of legality recognises a series of fundamental constitutional principles, such as that legislation does not bind the Crown, and fundamental individual rights recognised in the common law, and holds that Parliament is presumed not to intend to override those principles or rights, unless it makes its intention to do so very clear. As Lord Hoffman pointed out in the Sims case, the effect of this interpretive methodology is very similar to the operation of Section 3 of the Human Rights Act. Through the principle of legality, the common law supplies a form of presumptive constitutional order. Parliament has the power to disapply this order, but it can only do so by proceeding in the proper manner. By extension of this type of reasoning, certain statutes are regarded as having constitutional status as well, so that again, Parliament will only be capable of overriding their continued effect if it legislates in a particularly clear manner. That brings me to the most powerful illustration of the operation of the principle of legality. The question whether there are limits on the doctrine of parliamentary sovereignty itself to prevent Parliament from having the power to remove access to the courts, to challenge decisions taken by ministers or tribunals. The Privacy International case is now the leading authority. There were dicta in the case to suggest that there might be such a limit on parliamentary sovereignty. I'll make 2 points about this. First, there is no doubt that the presumption that Parliament does not intend to legislate to remove access to the courts in some shape or form is a very powerful one. This reflects the status of the rule of law as the second pillar of the Constitution, according to Dice's schema. Secondly, I have a degree of scepticism about the strength of the argument currently in the form in support of the idea that there is a limit on parliamentary sovereignty, as opposed to a strong presumption. That argument is that it is logically inconsistent with the state that Parliament passes legislation containing certain rights, and that it also legislates to prevent a person on whom those rights have been conferred from having access to the courts to enforce them. Something missing from this account is the fact that Parliament is not a singular entity which exists unchangingly across time. In reality and in constitutional theory, there is a series of separate parliaments, each of which is constituted differently after a general election and has a limited lifespan. Each parliament exercises agency of its own. Thus, at least where there is legislation passed by one parliament which confers rights, and the question is whether the legislation passed by another parliament is effective to prevent access to the court in some way, to enforce those rights. It does not seem to me to involve logical inconsistency to say that it may do. No doubt there is a very strong principle of comity between successive parliaments, that they will not likely undermine rights enacted by a predecessor. But that seemed to me to support the powerful presumption I've mentioned, rather than a rule which absolutely bars the later parliament from doing this. It is an orthodox feature of parliamentary sovereignty that it is continuing, and an earlier parliament cannot bind a later parliament. So I conclude. The question of the constitutional agency of Parliament is a complex one. We have to break down the concept of agency into political and legal elements. Parliament does not exercise agency in a full political sense. The executive is the body which does that. However, Parliament has a full power of agency in a legal sense. The basic rule of the UK Constitution is parliamentary sovereignty. In the Belmarsh case, Lord Bingham described this as the bedrock of the Constitution. Even though from time to time the question is raised, including in judicial dicta, whether it is subject to some limits and what they might be, I think that at the very least, the working hypothesis in an account of constitutional agency and constitutional principle is that parliamentary sovereignty is the rule. My third and final lecture about the constitutional agency exercised by the courts. I will examine this today further.